Hi everyone, and welcome to SATLA Deep Dives, a new video interview series where we sit down with leading voices in science and technology law for in-depth conversations on issues shaping the field. My name's Chris, and I'm one of the communications directors at the Science and Tech Law Association here at Melbourne Law School. Before we begin, I'd also like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional and enduring owners of the unceded land on which this interview is hosted today. We pay our respects to the elders past, present, and future. And with that, let me introduce my guests for today, both of whom have spent their outstanding careers at the heart of data and privacy law. Mark Taylor is Director of the Collaborative for Better Health and Regulation at Melbourne Law School, and an internationally acclaimed expert on privacy, data protection, and the governance of health and genetic data. He currently chairs the Data Governance Board for My Health Record, and previously chaired the Confidentiality Advisory Group in England and Wales. Mark helped draft the OECD recommendation on health data governance, and his work has influenced how governments and institutions around the world approach data governance. Philip Catania is a consultant at Corrs Chambers Westgarth, and one of Australia's most recognized technology and data lawyers. A graduate of the University of Melbourne in both law and computer science, Phil joined Corrs as a graduate and went on to serve as a partner there for more than 30 years, advising leading organizations on data privacy, technology transactions, and commercial intellectual property. He's regularly engaged on significant data privacy matters, including regulatory investigations by the Australian Privacy Commissioner, and currently sits on the advisory board of the Australian Cybersecurity School of Excellence at Uni Melbourne. I've had the great pleasure of being in both Mark and Phil's class, commercial data law, this semester. And once again, it's a genuine treat and privilege to have you here both as guests for the inaugural episode of SATLA Deep Dives. The first question, to set the scene for our viewers who won't have done a data law subject yet, how would each of you describe what commercial data law is and what drew you to it in the first place?
Well, Lon Fuller described the legal enterprise as the enterprise of subjecting human conduct to the governance of rules. So you might think that a data law subject is about subjecting data to the governance of rules, but it's not. It's still about human conduct. We're still talking about how people use data, how they collect it, what they can do with it, what they can't do with it, how organizations can protect the value in data. So it's about the enterprise of subjecting human conduct in relation to data to the governance of rules. So we have a very clear understanding of what is appropriate and inappropriate use. And what drew me to it? Why do I think this subject is an important one? Well, to quote somebody else, an English philosopher back in the 16th century, Sir Francis Bacon, said knowledge itself is power. And it's as true today as it was back when he said it. So understanding how people can use data, what they are permitted and not permitted to do with it, is a critical part of understanding how power is distributed throughout society.
I think what drew me to the subject is based on my practice and the practice of quote-unquote data law. Data pervades every aspect of legal practice these days, whether you're an intellectual property lawyer or a privacy lawyer, but also a real estate lawyer, an M&A lawyer, where all aspects of those practices are dealing with data on a day-to-day basis. Who owns data? How do we protect the data? How do we license it? How do we enforce our rights in respect of it? And so on. And there was never really a subject that dealt with that. It was dealt in part across various subjects. So, intellectual property law would deal with it in part. You'd have aspects of privacy law that obviously deals with it. But there was not a subject that brought all of those strands together and dealt with data, as you would know, Chris, throughout its life cycle. And so I remember speaking to the Dean about this quite a few years ago and saying, given its importance now and its relevance and its growth in practice and what clients are seeing with data, I think we should consider teaching it. And the Dean of the Law School at the time thought, yeah, that's a great idea, and we were fortunate to have Mark here, and we could combine academia and the practice side of it into a subject, commercial data law.
And so with that, I want to lead us to our next question, which is essentially on what it means to own data. As I see it, data sort of sits in this awkward position in the legal system in that you can't really own data from a legal perspective. There's no property right to it. And we always hear about our data, companies owning customers' data, and also selling those data to other companies even. So what does ownership of data mean? And is ownership the right word to use?
I might just give a view about that and then ask Mark you to add as appropriate. Yes, there's no such thing as ownership of data in the legal sense. Commercially, people say, yes, I own this data. I created it, or my business created it, or my staff did it, or whatever it might be, or the technology that I'm running created it. But in terms of, as you say, Chris, a proprietary right, that doesn't exist, absent, things like copyright in a database and you've got other rights that sit around it, the right of confidential information, for example, and other potential rights. And you've certainly got rights in personal information, but they don't connote ownership as such. So what happens when you own data, quote unquote, when people say, I own this data set? Well, they're really, from a legal perspective, it's about the right to control it, the right to allow others to access it, the right to allow others to use it. That's the right that we're talking about, a right of control. And we see this right to control as opposed to a right of ownership in other legislation, like the consumer data right, which gives consumers the right to control their data, the right to say to a financial institution, I want the data that you hold about me to be transferred to someone else. Now, in some respects, people would say that's tantamount to ownership, but in fact, it's a right to control. The consumer data right doesn't talk about ownership. It talks about the right to access and control it. And that's really what we're talking about in many instances. Absent any specific legislation or law that says, yes, you own the data, that's what we're talking about, the right of control and the right of access. Mark, would you say?
Yeah, absolutely, yeah. No, I've got little to add to that, except to acknowledge that looking at it that way explains why more than one person can have rights in the same data at the same time.
Yes, quite.
So as ownership, you would normally think, well, the person that owns it has the right to use it, to enjoy it, to exclude others from it, to sell it. We're not talking about ownership, but we are talking about those kinds of rights, but more than one individual, more than one organisation may hold those rights in relation to data. So as a consumer, I might have right to access the data that the organisation holds. Yeah. And that organisation has rights in relation to, and obligations in relation to that data as well. So it's really unpicking that bundle of rights, which is usually associated with ownership, and understanding who has which rights and obligations in relation to any data at any particular point in that data life cycle is much more appropriate and nuanced way of understanding actually what rights and obligations are engaged at any one point than ownership as a bundle.
And that's exactly right. You can still attribute a value to this, though. So it's not as if you say, okay, if there's no proprietary right, how do you attribute a value? But a value is attributable to it, because what you're saying is there is a value associated with me being able to control it, with me being in possession, in exclusive possession of it, with me having the right to say who will access it and use it. So when companies place a value in their balance sheet on their data, they're attributing a value associated with the right of control, the right of possession, the right of access, the confidentiality side of it. That's the value. And it is becoming increasingly the most important asset of organisations, their data, their knowledge, their know-how.
And I think with ownership, a more apt word perhaps for the average person when it comes to data is privacy. And so that's what my next question is based on. I think a lot of viewers probably won't realize that up until last year, if someone secretly filmed you, say, or a company leaked your personal information, you can't sue them for just the privacy invasion itself. But that changed last year in June with Tranche 1 of the Privacy Act reform. For the first time, Australians can actually take someone to court for a serious invasion of privacy through the new statutory tort. And there's also a much anticipated Tranche 2 of the Privacy Act reform, which is introducing the fair and reasonable test in saying that when a company handles your data, it has to handle your data fairly and reasonably, even after you've ticked "I agree" in the boxes following the wall of terms and conditions. So I want to ask the both of you on this as well. Do you think the fair and reasonable move, is that a right approach to data, or does that lay a fairness on top of consent, which sort of creates two conflicting concepts?
I think it is the right approach, and I don't think it necessarily conflicts. I think it usefully complements. It's worth noting, I think right now, there is a responsibility on organisations when they collect data to do so lawfully and fairly. But that responsibility applies only to collection. Yes. And what the Privacy Act review recommends is extending that to a responsibility to use and collect, use and disclose fairly and reasonably. And that, I do think, is a very important supplement to consent as a safeguard. Because if without it, if you're just leaving individuals to self-manage and protect their own privacy, you are largely abdicating responsibility for fair collection, use and disclosure to the individual's self-preservation in a marketplace where actually they may not have as much control as anyone would want and consent implies. If you say, look, as well as obtaining consent, you have still to ensure that any collection, use or disclosure is both fair and reasonable, you are applying an additional important safeguard, I would say. The question then becomes, well, what does fair mean? And there are different ways in which you can understand that. There is a relatively thin notion of fairness, which is about just transparency, it's about candour, it's about honesty, which is itself important, but only takes you so far, because as long as you do what you said you would do, it doesn't actually limit what you do. There's a slightly thicker conception of fair, which is one that I would argue is the one which we should be seeking to apply, and it is one that I think Australia is definitely moving toward, if not already there with our current Privacy Commissioner. And that's one where you have to justify any adverse impacts upon an individual's privacy as both necessary and proportionate. So there's no unjustified interference with privacy, which goes beyond just mere transparency and candour. So I do believe they are important safeguards which supplement consent in this context, because we know individuals' ability to effectively protect their own privacy is constrained by a whole bunch of things. The extent to which they feel that they have a choice as to whether or not to subscribe to certain services, whether or not they feel that even if they were to read the terms and conditions, they've got any agency when it comes to renegotiating them, whether it's just to take it or leave it. We have to make sure that the terms and conditions which they're being offered, the services that are being offered, the terms upon which they're being offered those services are themselves fair. And I think that's where extending the responsibilities under Australian privacy law to ensure that organisations are under an obligation to both collect, use and disclose personal information fairly and reasonably is a really positive step.
I agree, although I perhaps might place a slightly different slant on a certain aspect of it. But a few things to note, and we shouldn't be surprised by this coming from a practitioner's perspective. First of all, we are dealing with personal information only. We're not dealing with the broader remit of data, commercial data and trade secrets. We're only dealing with personal information. I think that's right. The second thing to say is that the adoption of a fair and reasonable test does bring us in line more with what's happening in certain overseas jurisdictions. So there's a level of consistency about that, which is good too. The issue will be what does amount to fairness and reasonableness, and in whose eyes, and what are the circumstances that will underpin the notion of fairness. So, for example, if I have clearly stated terms and conditions which can be properly understood, they're accurate, they're unambiguous, and the sorts of things that the Privacy Commissioner has been saying in her guidelines about, the sort of notices that need to be given. So if they are complied with, and so that an individual has a complete understanding and appropriate notice of how the personal information is going to be used, is that of itself fair at that stage? Or is there another layer that should be applied? That then goes to the question of the adequacy of notices. It goes to the question of someone's ability to engage with that vendor on those terms or vary those terms if necessary. So there is still a little bit, I think, to be thought through in terms of what is fair and in whose eyes, and what is reasonable and when it's unreasonable. And then whether or not, fairness and reasonableness changes depending on the nature of the information. So is it a higher bar when it comes to sensitive information and what is fair and reasonable? And I think, there's a good argument to suggest it should be something, there should be a higher bar of fairness and reasonableness. In other words, it will be unreasonable to use sensitive information in circumstances where you might allow non-sensitive information to be used. We'll think through that.
I'm super glad that collection and notice was touched upon, because that is exactly our next question. So think of a scenario where next time we walk into a big hardware store or a supermarket, and there's a decent chance that a camera from those stores will be scanning your face and turning it into a kind of digital footprint, and most people won't even have a clue about it. This blew up with the Bunnings case, which was extensively talked about in our elective class. And so Bunnings installed facial recognition cameras, and the regulators came after them. But this year, the Administrative Review Tribunal actually sided with Bunnings on the big question and said that Bunnings was allowed to use facial recognition technology to fight theft and protect their staff. But the catch is that they still got pinned on different grounds, in that they didn't notify people properly for using facial recognition technology, and they didn't have the right privacy systems in place. So first, a question for Phil. If a business owner is watching this, thinking about putting facial recognition technology or some other form of personal information collection in their shops, what's the one takeaway you'd want them to see from the Bunnings decision?
Well, I might just preface the specific answer to that question with just a couple of comments. What the Administrative Review Tribunal held in its decision was that the collection of what amounted to be sensitive information, being essentially the biometric template and the facial images of individuals, for comparison with facial images of people on a database, that in that instance, consent was not required for the collection of the personal information, because it fell within an exception known as a permitted general situation in the Privacy Act. That's section 16, capital A. And what's that exception say? That exception says that there's no requirement to obtain consent of individuals to collect their sensitive information if it's for the purpose of protecting people's safety or health, or because of some unlawful activity. And Bunnings' collection of personal information, this sensitive information, was always about seeking to prevent abuse of staff and customers, in particular physical threats, and also seeking to prevent criminal behaviour, and in particular theft. And so that's what it was all about. And on that basis, because the collection was for that purpose, it fell within the exception to obtained consent. But, as you say, the Administrative Review Tribunal held, notwithstanding the fact that consent was not required, you still needed to provide appropriate notice. You still need to have an appropriate policy dealing with privacy, and in particular. So what's the lesson then? Going back to your question, if I might say that it's all about ensuring every organisation these days, I think, more so, needs to ensure they've got much stronger than ever before governance in relation to the way that they deal with data, and in particular the way they deal with personal information. So the data governance is becoming so important as a role. So we now have, in many organisations, chief data officers. And indeed we have data ethics managers, people whose task is to determine how data is being collected, how it's being treated and how it's being used. And so the elevation of the role of the data responsible officer is important. It's a lesson that we're seeing, and organisations need to be paying more attention to it. The other thing that needs to happen is that, particularly when it comes to projects or activities that involve sensitive personal information, or personal information that has a greater risk associated with it, the importance of conducting privacy impact assessments before you deploy the project, before you implement the technology, for example. So if you're, as an organisation, want to implement a new customer relationship management system, and you're going to be collecting personal information or migrating a whole lot of personal information about your customers to a new system, and then part of it might be, I'm going to be exporting it or migrating it to an overseas, data hosting provider, then before you undertake that transaction, you should be undertaking a privacy impact assessment to determine what's the information that's going to be collected, where is it going to be stored, how's it going to be treated, what sort of contractual provisions should be put in place, how do you have it secured, who's got the right to access, all of those things. The APPs need to be looked at and considered as part of a privacy impact assessment. And it may be that out of that, you'd make recommendations about what you can and can't do, or you might say, well, you shouldn't even do this as an outcome of the PIA. These privacy impact assessments are becoming vitally important, particularly in the more sensitive projects that are organisations. That's the practical outcome, I think, of not just Bunnings, but many other cases that have been considered and investigations that the Privacy Commissioner has instigated.
I have a quick follow-up for our viewers. What exactly does a PIA, a privacy impact assessment, involve? Is it expensive for companies to do? Are there any difficulties for maybe, say, mid to small-sized firms that want to do a privacy impact assessment?
Look, that depends on a number of different factors.
We made all the students do one in the last class.
Well, we did, and
so really, you should be extremely well placed to say exactly what a privacy impact assessment involves.
we did, and of course there is a pro forma PIA on the OAIC's website that you can follow the structure and the nature of the questions that need to be asked. So, is it expensive? Look, it depends on the project. Mm-hmm. If it's a particularly complex project that involves a number of different participants, highly sensitive information, if there's the potential for significant risk, then it'll be more expensive. We're not talking about millions here, though.
Probably not as expensive as not doing one.
Well, this is it.
Because if anything goes wrong, I think it's fair to say that one of the first questions you'll be asked is, did you conduct a privacy impact assessment before you?
Absolutely. So the Privacy Commissioner rightfully and understandably will say, well, if this is a sensitive project that you're looking at implementing, where is your PIA? What did you do? And in fact, it might be that in addition to privacy impact assessments, you'd be doing a human rights impact assessment as well. And more broadly, an information security assessment that may be dealing not just with the privacy of the personal information, but information security more broadly. You can't skimp on these now. And the Privacy Commissioner has made it clear that, in fact, cost, whilst it's important to look at cost in terms of what you do, it shouldn't be the determinant. Just because something is too costly shouldn't be a reason not to do certain things. Noting that at the moment in Australia, conducting PIAs is not mandatory. Now that may change, either in the second or subsequent tranches of privacy reform. My sense is that it probably will be made in certain circumstances mandatory, and I get that. Don't you?
I would love to provide a essay templated answer on what a PIA is, but I would argue that we have some more interesting questions to get through in the meantime, though. So, Mark, I want to shift our lens to the health sector. When we go for a CT scan, I think patients will just be thinking about their health and not really thinking about what happens to the scan data itself afterwards. One of Australia's biggest radiology providers, IMED, handed nearly 30 million scans between 2020 and 2022 to an AI company, Analyze.ai, to train a diagnostic tool. Nobody was told, nobody was asked. The regulators said there was no breach on this case because the scans were de-identified. Would any patient really expect their scan to train a commercial AI? And is the regulator's decision to say that there was no breach resting on solid legal principle, or just the promise that the data can't be traced back and hence everything's fine?
Well, I think that particular, there's lots of questions bound up in your question there, Chris, but I'd say, do people expect it? I don't know, to be honest. I think it would probably depend on the person and just what notification they were provided. Here, I'm not sure much notification was provided in relation to de-identification and disclosure for the purposes of training an AI system. But I think that speaks to what I see as a larger problem with privacy law generally. Privacy law takes its kind of object of concern, personal information. So information about an identified or reasonably identifiable individual. That's true in Australia, but it's also true overseas, where they might not talk about personal information, they might talk about personal data, they might not talk about personal information or information about an identified individual, they might talk about information that relates to an identified individual, but it's the same idea, broadly speaking, that if we're interested in protecting privacy, we're interested in protecting information about identifiable individuals. As soon as it stops being information about a reasonably identifiable individual, privacy law expectations and obligations largely fall away. And there might be some residual obligations in relation to maintaining the de-identified status of the information, which might require strict controls around context and mitigating risks of data linkage with other data sets that would permit re-identification. But this is all about just trying to stop information becoming personal information again. If we can effectively de-identify data so it's no longer personal information, an awful lot of the obligations that are imposed just disappear. And I personally think this is increasingly problematic when it comes to ensuring adequate protections, including privacy protections within a modern information-rich economy. Privacy is largely about control over information, but it's because information and the control of information impacts us in very many different ways. And it's not only information about us as identifiable individuals that has an impact. Information that relates to us as groups also has a profound impact upon us, as data relating to profiles and group characteristics increasingly shapes the opportunities individuals ultimately have within a digital environment. So my own view here is that although it may have been correct according to current law, and there is a question about, we could argue about that, I'd rather use it as an example to demonstrate the deficiencies of an approach which focuses entirely upon personal information and nothing else. I've always been bemused by the fact we're so concerned about how we control data when it relates about one person, but we don't express the same concern over how we control data when it relates to 10 or 1,000 or 100,000. When the uses of data can impact people in adverse ways, I think we should care about how it's used, and we should control its use. How do we do that when an awful lot of the law currently is built around this notion of personal information? Well, there's various ways in which I think we can move towards this by making sure that notification at least extends to de-identification and intended purposes at the point of collection. So I think people should be notified if at the time the data is collected there is an expectation and intention to de-identify the information and use it for purposes that they might care about, they might be concerned by. And I also think that the privacy impact assessments that Phil was talking about earlier should have a broader scope than information as it relates to the identifiable individual, but consider the impacts and the consequences of the uses of the data for individuals as members of groups as well.
If I may add to that, and Mark certainly alluded to this, there's the issue of choice and individuals having the right to say, no, I don't want my information to be used, irrespective of whether it's de-identified. Now that's perhaps taking it a step further. Some people might say, if I go in and do a scan for a health issue that I have, before you take my scan, specialist, I need to let you know whether or not I'm going to allow you to use this for research purposes or for assessment purposes, or to put into a database and so on. Now, some people say, so long as it's absolutely de-identified, and we do have to make sure that that's the case, then I'm happy with that. I expect many people would say that. Some people, I expect, would say no. So we need to give people, I think, in that instance, the choice. That choice is reflected already in things like, as I said, the consumer data right, where an individual has the right to choose who holds their data. Is it that bank or is it that bank? I want to have the right to choose whether or not personal information, particularly sensitive information about me, is used for any purpose. I may say I only want to use it for my purpose and for nothing else. And then I think we do have to set some further standards about de-identification. I think there's much more work that needs to be done in terms of how we determine that information has been permanently de-identified and cannot be re-identified. I know the Privacy Commissioner has spoken about this and has issued some guidelines about this. And I think before we proceed with this notion even of using de-identified information, we have to really be very clear about what de-identification actually means. More work needs to be done on that.
Thank you for those insights. The next question is actually something highly topical for our law students, the Canvas cyber attack. This is something that affected all law students. Canvas was hacked by a massive hacker, and this is the largest educational security breach in history, I believe.
Worldwide breach, wasn't it?
Worldwide,
Yeah.
yes. I think, over 8,800 institutions across the globe, names, student IDs, and even private messages between students and teachers were leaked. And so I think the aftermath was that Instructure, the Canvas parent company, ended up paying a ransom to Shiny Hunters, which was the attackers. So I think most people would hear about this incident and think, oh, hacking and cybersecurity or computer science. But as I know, and I'm sure you do from our class, this is a very topical data law issue. So I want to ask you both, why is this incident a data law issue, first of all, and what does it speak to the current state of data law, say in Australia, and also how we handle security breaches?
Well, if I may, why is it a data law issue? Because you're dealing with unauthorised access to data, which is very different from dealing with unauthorised access to real property, for argument's sake, or physical property. It's the sort of, what are some of the differences? And these are obvious and you'll understand them, but we have really difficult jurisdictional issues because most of the cyber attacks occur from outside of Australia. Not all of them, but most of them. So enforcing rights against people in other countries is difficult. That's number one. Number two, we don't know who they are, as in we don't know who the legal entity is. We don't know if there is a legal entity. We know there are people who are doing this, clearly, or indeed in some instances, this is another issue, it may not be people. It could be new technology itself that is being directed by organisations to engage in cyber attacks. And we've seen how, in fact, with certain AI models out there that have been developed specifically to try to detect vulnerabilities in systems and effectively engage in some respects, the white hat type of attack. So you've got issues about jurisdiction, you've got issues about who the entity is that's engaging in this, and you're also dealing with organisations, quote unquote, whose business is to engage in cyber attacks and to extort money. That's their business. It's their business model. And we know that if you don't pay the ransom, then in many instances they will publish the data. We've seen that here. And we also know that in many instances, but not all, if the ransom attacker doesn't do what they said they were going to do, if you pay the ransom, that's bad form, and that next time they do it, people won't pay them. And so ordinarily, but not always, the ransom attacker does what they said they were going to do. There's sort of honour amongst thieves to a level. These are really peculiar and difficult circumstances, and there's a whole, I think, there's a business stream being set up. So you've got specialist ransom negotiators now developing relationships with, quote unquote, relationships with cyber attackers. And of course, the payment is not done in ordinary currency. It's usually some sort of cryptocurrency which can't be tracked. These are all the unique circumstances. But at its core, we're dealing with data. Now, how do we approach this? In Australia, a couple of relevant things. It's not an offence to pay a ransom. There's a requirement now under our Cyber Security Act to report the payment of the ransom within a certain amount of time with certain information to the Australian Signals Directorate. That's to try to develop as much information as possible about what's going on with a view to engaging in preventative action and education and so on for the Australian community, and that's good. It's not an offence, though, to pay the ransom. And indeed, some organisations here in this country may conclude that it's in our company's best interest to pay the ransom. So you've now got issues relating to directors' duties and the sort of things that directors need to consider about whether or not they need to pay a ransom. That's a side effect of that. But what I would say is that there is work going on about this, but this is an international problem. It's not just an Australian problem. And so there's work going on, but there's much more work that's needed on an international scale. We're seeing some great work being done within say, the banking industry in Australia. The banks have gotten together and they work actually quite closely with one another to exchange information, understand security postures, and work with one another to try to minimise. It's not in anyone's interests, not in the banking industry's interests in Australia, if one bank is attacked. So they work together closely. Now, I think we're working on an international scale, because it's an international problem, and that I think there's more work that needs to be done on that front, in the same way that there's more work that needs to be done in terms of how AI is being used. And I know we get to that in a little bit, but it's an international issue. This transcends boundaries. It's not just an Australian problem. We know that.
I'll just briefly add to that, because I think that's absolutely on point. And one of the challenges here is that it's an international issue, but they're also often international actors, and we're relying upon domestic law to try and address it. But it is worth noting that in relation to the international actors, you've got the bad actors and you've got the organisations that are being engaged to provide the service, who may also be international. And there is an extraterritorial application of domestic law when an overseas organisation is carrying on business in Australia. So there is some opportunity for domestic law to reach through and impose obligations upon organisations, even if they're not located in Australia, if they're not Australian incorporated entities, they may still be subject to obligations under Australian law. And if they're not carrying on business here, then the organisations that are here and subject to Australian law may themselves be may be under obligations in relation to what those overseas actors do. So there is an effort, I think, to try and ensure that even though the international dimension is addressed.
I mean, cyber attackers, you might be argued that they're carrying on business in Australia, but they're not going to be admitting that they're carrying on. I mean, it's going to be difficult to ping them for breaches of privacy. But, I mean, we've seen international cooperation in many respects in sort of the intellectual property field and in trademarks and in copyright and in the World Intellectual Property Organisation, for example, WIPO, engaged in enforcing and dealing with international treaties. And, work is being done on setting up a global cybersecurity group whereby member countries participate and agree to enforce certain rights against their own individuals for cyber attacks that might occur in other jurisdictions. And we've seen it. We know that, in recent times we've become aware, and governments of certain countries have found the bad actors. What we want to see is, of course, that being dealt with, as Mark says, internationally and by their country where they reside, or they're a citizen, or they're otherwise engaged in the activity.
It's remarkable how many interdisciplinary factors come into play with just this one issue. As we know, with the surge of AI and everything else exciting happening in the field, there are lots of students who are increasingly interested in data and privacy and tech law in general. So one final, last but not least question for the students that are going to be watching. What's one word of advice you would give to students who want to pursue a career in commercial data law?
I'll give you 2 words. Do it. Look, it's a growth area of practice. It's one of the areas that is not just growing, but will continue to grow at a pace. Why? Because, as many people who have heard me speak about this, it's becoming all about data. Whether it's AI or whether it's cyber attacks or whether it's the privacy of individuals, this is all about data. So it's a growth area. And we are yet to see, a lot of the litigation that's going to arise. I mean, there hasn't been, any case decided on the statutory tort of privacy as yet. Now, that will come. And we're seeing, all sorts of actions being taken both at an individual and a class level associated with data breaches or privacy breaches. Now, that's unfortunate in one sense, but it will happen. We're seeing an increasing amount of data licenses being developed and negotiated and agreed. We're seeing more people claiming rights in their data. And I'm not just talking about personal information, I'm talking about data more broadly. Confidential information, trade secrets, know-how and so on. It's a growth area and it's going to get bigger. So, and it's going to be relevant, as I said at the start, to every area of practice. If you are a real estate lawyer and you're negotiating a lease, there will be provisions in it dealing with the data that's been collected by the lessee, for example.
I don't think I can say it better than that, really. Just do it. I mean, it is such a dynamic and it is such a growth area. I would encourage people to engage the media on this, read the news stories, but also check out the websites of the regulators, see what regulatory action's being taken, what kind of forums. They often run forums and seminars, watch, listen. There's lots going on legislatively, so discussion papers are put out, consultations, read them. You will ultimately want to become expert in an area because it is such a broad area. You know, you can't be an expert across it all, but it is good to stay across the area as much as you can generally because it is such a growth area and there's so much going on, so much innovation happening in different areas. There'll be a lot of cross-fertilisation when it comes to good ideas as well, and understanding how the broad regulatory landscape is shifting and forming a view, your own view, about how it ought to shift so you can not only engage with this but critically engage and form your own opinion. Because ultimately we need you to come into practice critically aware of what's happened, the history of it, but also a sense of what we should be trying to achieve here. Because there is a tremendous opportunity here to help shape the future, because so much of it is going to depend on how data is regulated.
Well, with all of those in mind, Mark and Phil, I want to thank you both very much again for taking the time to have this wonderful conversation with us. It's been deeply engaging and insightful, and I'm sure you'll be expecting a long line of students signing up for the commercial data law class next semester. Is it offered every semester?
Has been so far.
Well, I think you might have to find a bigger classroom, even bigger than the one so far. But yeah, thank you so much.
Cheers, Chris.